here with PSS Life University. We have a really important topic today, I think. Matt and Cindy were just talking about this. People who on disabilities, there are so many good programs out there, and people shouldn't miss out on them if you're disabled. And the other side of it, as you'll see, is there's always a risk about losing benefits, but definitely some important strategies to be aware of to protect your benefits. So let me just share my screen and we will get started. Okay. So that's our law firm, Lamson Cutner. You can see we have offices in New York City and in Westchester County. Today's topic is disability planning. And, oops, why is this not moving? Oh, there we go. Again, thank you to PSS for hosting and sponsoring this event. So, as I started to say a moment ago, I think the two key areas in disability planning is number one, obtaining benefits. And for that, we need to understand what's available and how to be or become eligible for those benefits. And the other side of it is if you have benefits, let's not lose them. And oftentimes gifts, bequests from people who are well-meaning turn out to be problematic because the receipt of the gift or the bequest winds up making the disabled person ineligible for an important benefit. The same if the disabled person has filed a lawsuit and has a recovery, and maybe that person is disabled because of some event like medical malpractice or an accident of some kind, and now has sued to recover damages. And all of a sudden, the success of that lawsuit results in the loss of benefits. It doesn't have to be that way if we know how to plan for it and deal with it. So let's start with the what I think are the main government benefits available. Social Security Disability, Supplemental Security Income, SSI, Medicaid, of course, subsidized housing, and food stamps. So we'll take a look at each one of those, not in any great detail, but I think these are the ones that disabled people need to be aware of. All right, so let's start with SSD. This is, of course, administered by the Social Security Administration. And importantly, it's not based on your individual financial situation. If we're looking at Medicaid, we need to look at your resources, your assets, and other programs as well. But here, it's not a factor. If you're someone whose condition is such that you're unable to work for 12 months or more, you are probably going to be eligible for SSD. And the amount that you receive as Social Security disability is going to depend on how much you've paid into the Social Security system. So if you've been working and you've had those payroll deductions from every paycheck, that's all been contributed into the Social Security system. So the work that you've done and what you've paid into the system is going to determine the amount of your benefit. And if you remain disabled for 2 years or more, you will be eligible for Medicare. most people think of Medicare as a benefit that's available to you when you're 65. But if you're under 65 and disabled, you can become eligible for Medicare. And Medicare, of course, is a really excellent medical insurance. So again, your eligibility is not based on your assets or your income. So if you receive a gift or bequest or a judgment or settlement or whatever, you are not going to lose your benefits. So SSI is also financial. You would be receiving a payment from Social Security Administration. Eligibility starts with your age. If you're 65 or older, or if you are disabled at any age. So again, similar to SSD, it's the inability to work for 12 months or more. And now, though, you have a means test. So we're looking at your your resources. So you can see the numbers are small, very small, no more than $2,000 for an individual or $3,000 for a married couple. And the benefit, $967 a month for the individual or $1,450 for the married couple. One of the, I think, important things about SSI is if you qualify for SSI, you automatically receive Medicaid. And that's a huge benefit because Medicaid not only covers your medical care, it also covers your long-term care. And long-term care is not something that is covered by Medicare. Only Medicaid will pay for it. And it's very, very expensive, very expensive. We see clients who are spending $5,000, $10,000, $15,000, $20,000 a month on long-term care. It is incredibly expensive. So if you are eligible for SSI to get that Medicaid benefit along with it, it's definitely a good thing here. So let's take a look at Medicaid. And I give presentations about Medicaid that take collectively about 4 hours. So I only have a couple of minutes here. It's a complicated area, but here are the basics, I think. To start with, Medicaid is a partnership between the federal and state governments. And we have federal law and some federal funding, and then we have state law and state funding. And for most of the programs, apart from nursing home, the funding is basically coming from the state. It matters a lot where you live. Some states are more generous than others, and some states really stand out. And then there's one state that is the best of all by far, and that's New York State. There's no question we have the best Medicaid program in the country. We spend more money in absolute dollars, and we spend more money per person than any other state, and by far. So we have more benefits and more going on with Medicaid in New York than you would find anywhere. And I know there's been a lot of concern in recent days about what's going on in Washington, and is the government going to continue to support the Medicaid program? I just want to say here that, none of us has a crystal ball, so we can't make any promises or guarantees about what's going to happen here. But I'll say from my own point of view, I'm extremely doubtful that we're going to have a problem with Medicaid in New York State. It's just such a big economic force and job creator. It's not just taking care of people who are old and sick. It's creating jobs for thousands and thousands and thousands of people, whether it's in construction or linens or food and laundry and medical equipment. I mean, it's absolutely endless what's involved in providing this type of care. So eligibility, and I know there's a lot of confusion about how to become eligible for Medicaid. It is not, and I'm going to repeat this, it is not based on your income. I hear all the time, oh, you have too much income to be eligible for Medicaid. Not true. The eligibility test is based on essentially your financial assets. What do you have in your bank account, your savings account, your investments in securities, mutual funds, and so on, and to some extent, real properties and co-ops and stuff like that. But it's based on assets, not on income. If we're in a nursing home and we're asking Medicaid to pay the bill, we do have to comply with the 5-year look back, where Medicaid is looking to see whether you have gifted or transferred money or property to somebody else, or to a trust. If you've done that, nobody's going to say that that was wrong or illegal or improper or unethical or anything like that. Medicaid's remedy is simply to say you are not eligible to have us pay your bill for you for a certain amount of time, which is calculated based on what you have transferred during that look back period. Your income is essentially given to the nursing home. You can keep $50 a month. Now, the community side is different. For community Medicaid, which is all the other programs other than nursing home. So we have home care and adult daycare, and we have assisted living, and we have all kinds of special programs depending on your illness or your medical condition. Here we have no look back. As we see on this slide, there's been a lot of talk about a look back. It's been delayed and delayed and delayed since 2020. So here we are 5 years later. It still has not been implemented. Personally, I don't think it will be. But anyway, we shall see. Your income, essentially you can keep your income if you access what's called a pooled income trust to protect what Medicaid would call your surplus income. So that's an amount of monthly income that is above the Medicaid level, and those levels change every year. So again, Medicaid's a big subject. That's about all the time I have for it today. So if you need to know more, you can maybe attend another PSS event where we talk about Medicaid, or call our office. Okay.
David, I have can I interrupt? There was a question regarding SSI and SSD. So can I interrupt you and ask that question right now before you move on?
Sure.
Okay, so a person asked, I have heard that you can be on SSD and SSI. Is that correct? If so, as a couple, you couldn't have more than $3,000. Could you move anything above that into something like an ABLE account to keep you qualified, or is there something better? But can you can you explain how SSD and SSI work with each other?
Well, it's more on the SSI side of qualifying for that, because as you can see, the resources that you can have in your name are limited, very limited. But having money in a trust or transferring your assets to a family member may get you there. But you know, this is really a discussion to have on an individual basis. There are strategies that help with SSI as they do with Medicaid. But as we also see, the question really is about SSI, because SSD, there's no financial qualification.
Right.
You know, if you're disabled and you have worked and contributed into the Social Security system, you're eligible to receive a benefit.
Okay, great. Thank you.
Okay, so moving on to the next benefit available to that may be available, it would be subsidized housing. So, you know, I'm not going to spend a lot of time on this here, but there are programs in New York State that are available to help with housing expense, particularly the DRE and the SCRE. If you're disabled and under the age of 65 with low income, you can get exemptions from your rent payments, and also senior citizen benefits as well. And there are also, I guess it's not up on this page, but there are also some property tax credits that you can get as seniors as well. And then I think the last one I wanted to mention today was food stamps. So again, you need to qualify for the food stamps program, but you can see there's a nice monthly benefit there if you do qualify for it. And you can see, by the way, on these slides, you know, you've got the reference where you can take a look on the internet and find detailed information about these programs. Okay, so let's talk now, and I think this is a really key part of the discussion today, is how do we plan? How do we plan to become eligible? How do we plan to get benefits and keep benefits? Because I think it's really sad when someone who's disabled receives a well-intended gift or bequest, for example, which in the end has an opposite effect of causing a problem for the much needed benefits that that disabled person is receiving, like Medicaid or food stamps or you know, any of the others that I mentioned. So again, I'm going to start with the Supplemental Needs Trust, which is kind of the major piece of disability planning. And let's first understand what a trust is. So I put this slide here on trust basics. So I always say to clients, the best way to understand a trust is to think about it as another person. Because legally, a trust is another person. It's obviously not flesh and blood, but a trust can have a bank account, it can have an investment account, it can own real property, it can own a co-op, anything that any of us could own or does own a trust can own. All right, and it is an entity that lawyers create for their clients, but it's kind of like a corporation or a limited liability company or a partnership, except trusts don't have owners. Nobody owns a trust. It's a pure person legally. So again, if you're thinking about a trust, think about it as another person. So second point is, how do you create a trust? It starts with a trust agreement. So the agreement is between the person who is funding the trust or putting assets into the trust and the person who is going to manage the trust, called the trustee. So again, be aware that nobody owns a trust. The trustee is a manager, as somebody who's essentially an employee of the trust, but doesn't have any ownership interest. So the other part of trusts are that typically it's part of the trust agreement to say who is going to benefit from the trust. And that could be benefit both during lifetime of the grantor, the person who created the trust, and after the death of the grantor. So to some extent, trusts often look in part very much like a will, a last will and testament, because the trust is going to say who is going to receive the benefits of the trust. So there's all different kinds of trusts. The ones that we're going to talk about today are supplemental needs trusts, but all trusts have in common the elements that I've just mentioned. So what exactly is a supplemental needs trust? And sometimes, by the way, these trusts are called special needs trusts. So if you hear that term, a special needs trust, it's the same thing as a supplemental needs trust. I think the most correct and preferred name is the supplemental needs trust, but special needs trust will do as well. So the idea of this trust is to hold money, money or property that can be used to supplement the care and support of people who are disabled. And we want to do this in a way that will not affect their eligibility for government benefit programs. So we want to, if we're having a supplemental needs trust, we want to be able to get Medicaid or food stamps or any of the other benefits that I've already mentioned, and not have the money in the trust, which is there for our benefit, compromise our eligibility for these programs. So that's what the supplemental needs trust is about. It's to provide additional care and support for someone who is disabled, but not interfering with their eligibility for government benefits. So what does it mean to be disabled? Well, here is the definition that comes from the Social Security Administration. So basically, you can't work and you have a condition that is going to last for at least 12 months, or that might be expected to result in your death. So that's kind of the official definition of disability. So let's turn now to the kinds of supplemental needs trusts that exist. You can see on this slide, we've got the first party supplemental needs trust, the pooled trust, and the third party supplemental needs trust. And you can see on this slide, I put inter vivos or testamentary. So what I'm referring to there is an inter vivos trust means a trust that you created during your lifetime. And a testamentary trust is one that you have created under your will or under another trust. So an example of a testamentary trust would be, let's say you have a disabled child, a special needs child. And of course, you're going to leave a bequest to that child in your will. But if you made that bequest an outright gift of a sum of money, for example, the receipt by your child of that gift would very likely compromise his or her eligibility for the programs that they're benefiting from. So in that type of situation, that's where you would have a testamentary supplemental needs trust. Your will would say, I'm leaving $100,000 to my son James in a supplemental needs trust, which will make that bequest available for his support and care, but not interfere with the government benefits that he's receiving. That's a testamentary trust. And inter vivos is, again, a trust that's created during your lifetime. So let's take a look at the first party supplemental needs trust. So the reason why it's called the first party is because the trust is being funded with the disabled person's own money. The trust can be created by the disabled person himself or herself, or by a parent or guardian, parent or grandparent or guardian, or by a court. The disabled beneficiary of a first party supplemental needs trust needs to be under the age of 65. And whatever is going into that trust has to be put in or added to the trust before that person becomes 65. And the beneficiary of the trust must be disabled under the Social Security definition. So that's why I put this slide up here, because when we're thinking about these trusts, we need to bear in mind what it means to be disabled. So again, physical or mental impairment, which prevents the person from being able to work for at least a period of 6 months. 12 months. All right, so we need to bear that in mind when we're thinking about this type of trust. And then that last point on this slide about it being a payback trust. So what this means is that if you have a first party supplemental needs trust and you are receiving Medicaid benefits, Medicaid is going to allow you to keep receiving your Medicaid benefits, even though there may be a lot of money available to you in your first party supplemental needs trust. However, Medicaid is going to require that if the money in that trust is not spent during your lifetime, then Medicaid has the right to receive reimbursement for whatever expenses it has incurred on your behalf during your lifetime. So that's why it's called a payback trust. Okay, so when do we think about a first party supplemental needs trust? These are the typical situations. I think I've already mentioned this. The receipt of a gift or a bequest and something that we've inherited. And, again, it's unfortunate that the person who has included the disabled person in their will, which was thoughtful and well-meaning, the fact that that bequest was made as a cash bequest or property directly to the disabled person may again turn out to be unfortunate because it's likely to cause that disabled person the loss of his or her benefits from Medicaid or one or more of the other programs. And the same with a gift. A cash gift can be a problem. And then we have, of course, the lawsuits. And it's so often the case that somebody has had an unfortunate accident, an injury that results in disability, and whatever occurred that caused the disability provided a basis for a lawsuit, which results in a settlement or a judgment in favor of the disabled person. Okay, that is the time when a first party supplemental needs trust is going to be needed. And I think it's fortunate that lawyers who work in the field of personal injury law, most of them are aware that that can be a problem and raise the issue. But it's important for people who are disabled to be aware of it for themselves, that money they receive from any source can compromise their government benefits. So another type of trust that is really, in effect, a first party trust, right? That is a pool trust. And for those of you who are familiar with Medicaid, the use of a pooled income trust is really prevalent for almost everyone who's applying for community Medicaid, for home care or assisted living or one of the other programs. Because if you have surplus income, you're going to have to contribute it to the cost of your care unless you put it in a pooled income trust where it remains available to you. So, of course, most people who are applying for Medicaid are also joining a pooled income trust. But the nonprofit organizations that operate pooled income trusts also operate asset trusts. So you can put your assets as well as your income into a pooled trust. All right, so now you have a nonprofit organization that is managing that money, and it can be used for your benefit, and it does not compromise your eligibility for programs like Medicaid and food stamps and so on. So why would you do that instead of a first party supplemental needs trust? Well, maybe you don't have family or friends or anybody close to you that you would be comfortable in naming as trustee of your first party trust. So that's a factor in many cases. Another factor is age, right? Because the first party trust is available only to people who are under the age of 65. So what are you going to do if you are 65 or 66 or 70 and now you are on Medicaid and receiving food stamps, and all of a sudden you receive a bequest that you were not expecting, or you settle that lawsuit? You can't create a first party trust. You're too old. So here's an option that is available to you. So it really depends on the individual circumstances. You can see there are other things that may weigh into the equation when this is being considered. Like, are we going to need to go to court to set up that trust? If so, how long is it going to take and what is it going to cost? Maybe under that circumstance, we'd prefer to set up the pool trust, which is easy to do and not very costly. On the other hand, what if it's a lot of money and it's predictable that it's not going to get spent during your lifetime, and maybe even after the Medicaid payback, there's going to be money left over for family members. So, like every case is different. And we just have to weigh what the best option is depending on the individual's circumstance. But again, you're receiving government benefits. You receive money from some source that will compromise your benefits. Your choice is going to be the first party supplemental needs trust or the pooled asset trust.
David, can I ask a question here?
Yes, you can.
Okay, thank you. Actually, this was Matt that asked this, and this is a good question. So if you have one of these trusts and you get a windfall, should you notify Medicaid, or what do you do if you learn that your grandmother died and she left you, $100,000 because she knew you were disabled? What should you do?
Well, it depends. If you're at a point in time where where your Medicaid renewal is coming up, which is an annual thing, you're going to have to report the receipt of the money, but you'll show that it went into a pooled income trust. You're not going to have a problem. But I think in many cases, you just put it in the trust. If it remains in your account, your own personal account, you're going to run into a problem with Medicaid. But, use of these trusts is really foolproof. This is what they're designed for. And Medicaid will recognize them. You're not going to have a problem with this type of trust, whether it's a pooled trust or a first party trust. So I don't think there's really any reason for concern, as long as you take, again, the appropriate step, which is you're in a government program, you receive money that would make you ineligible, put it in a pooled trust or put it in a first party trust. Okay?
Great. Thank you. Okay.
So let's take a look now at the third party supplemental needs trust. Again, it's called the third party trust because it's created by a third party, not the disabled person. So this might be an aunt, an uncle, a friend, anybody really who wants to do something to help and benefit someone who is disabled. So you'll see here on this slide, the one exception is you cannot create an inter vivos supplemental needs trust for someone to whom you owe a duty of support. So you cannot set up a third-party trust for your spouse, for your minor child, right? Because you're obligated to support them anyway. So it's not permitted. But listen, once your child, if he or she is disabled, becomes 18 years of age, now that person is no longer a minor child, and you can create an inter vivos trust. And you can certainly create a testamentary trust for a spouse, for a child. That's really very common. When spouses are elderly and health is failing, it would be typical to, one spouse dies, for that spouse to leave the money and property to the surviving spouse in a supplemental needs trust. And of course, if you have an adult child who's disabled, then you certainly want to leave money to that child in a supplemental needs trust. So there's no age restriction. There's no payback to Medicaid or anywhere else. So when you create a third-party supplemental needs trust, you're going to name contingent beneficiaries. What if the money in the trust is not used up during the lifetime of the disabled beneficiary? You can name the next person in line who you would like to benefit. So we typically would be including contingent beneficiaries, even though it's a supplemental needs trust. And of course, you select the trustee of your trust to manage the money or property for the benefit of the disabled beneficiary. So here is precisely where the rich uncle and other family members and friends who want to do something to benefit a disabled person, please, please, please do not make a direct cash gift. Let's think about a supplemental needs trust if it's any significant amount of money or property. Right? This is just good planning and the smart thing to do, the sensible thing to do. Okay. So here I put some the important provisions of these trusts. Again, the idea of the supplemental needs trust is to supplement. So it can't take the place of benefits that are available from the government program that the disabled person is on. It can supplement those benefits. So, here's a common example. Somebody has Medicaid home care, and Medicaid is providing 8 hours a day of care covered by Medicaid. But that person who's on Medicaid has a supplemental needs trust, and it's believed that the 8 hours a day are really not sufficient. We need 12 hours a day. Well, the supplemental needs trust can pay for the additional 4 hours, and Medicaid pays for the first 8 hours. So that's a common example of how this type of trust might be used. The beneficiary of the trust has no authority to revoke it or change it or demand anything from it. The trustee is in charge, and the trustee and the trustee's discretion will decide what will supplement the life and comfort and support of the disabled beneficiary. So again, you want to be careful about who you select as trustee, and make sure that that person has the best interest of the beneficiary in mind and do what would be best to supplement that person's life and care. And again, the type of care that are things that are supplementing, it doesn't have to be medical care or home aids. It can be that, but it also can be things that entertainment, books, anything, equipment, anything that's going to make the life of that beneficiary better. I say that on this slide down there at the bottom. Anything that can be used to enhance the disabled person's quality of life, education, recreation, entertainment, and so on. Okay, so let me move on to another topic here, caregiver agreements. And I put this into this program because it can play an important role, as you'll see. It's a personal services contract or agreement between the disabled person and a caregiver. And the caregiver could be the disabled person's own children or siblings or friends or whoever. It could be anybody. And the services, the personal services, can be care services or financial management or even just companionship. And the services can be paid for in advance. And as you'll see, that may be a useful thing when we're involved with Medicaid. So whenever I raise the topic of a caregiver agreement with clients, sometimes it makes people uncomfortable because they think, why should I be paying my own daughter or my own son to take care of me? And maybe the son or daughter is thinking the same thing. But as you can see on this slide, there are actually good reasons why that payment might be a good idea. Maybe that child is giving up a job or doing less work and not getting paid as much. Maybe they're losing time with their own family or other things that they might be doing. Maybe they have siblings who aren't doing much to help mom or dad, and they get stuck with it. And maybe those siblings who aren't doing anything won't feel guilty or embarrassed about not doing anything if the one who is helping out mom or dad is getting paid for it. So maybe it makes everybody feel better about the situation. And oftentimes, and this is, I think, an interesting part of it, is that the caregiver agreement may actually help the parent qualify for Medicaid. And we see this, I would say not with great regularity, but it does come up where, somebody has too much in the way of assets to qualify for Medicaid. But if they could just get rid of $30 or $40 or $50,000, it would bring them down to the Medicaid level. And here's the answer. Enter into a caregiver agreement and pay for it in advance. And so now you've made a payment that Medicaid will recognize as a proper and valid payment, and it leaves you with assets in your own name that make you eligible for the program. And further, I think those who are disabled are maybe happier knowing that it's their son or their daughter that's helping them out, because that person would know them best and certainly be devoted to their welfare. So,
David, sorry, there was another question.
sure.
Actually, sorry, two questions. So if with the supplemental needs trusts, if you want to go on a vacation, would that include like a nice, fancy, expensive cruise? Who has the discretion to decide whether or not it's for your benefit?
The trustee.
The trustee.
You could say to the trustee, I would like to take that fancy cruise, and the trustee might well say, yeah, I think that would enhance life for you. Let's do it. And pay for your caregiver to go along with you at the same time.
Great. Oh, yeah. Now there.
And well, I mean, that could be, depending on how long the cruise is and so on, that may be problematic if you're on Medicaid, but, maybe you're not on Medicaid and you simply have a supplemental needs trust. Yeah, why not?
And you actually might need the caregiver to go on the cruise with you if somebody's taking care of you.
Well,
a caregiver, yeah.
Probably you would. I think in that kind of situation, we'd want to consider how old is the disabled person, how much money is there in the trust, because the trustee has a responsibility too to be prudent about what you're doing with the money that's in the trust. So, if we blow it all on the cruise and the person still has 25 years to live, that may not be the smartest thing to do. But
right.
But sure, I think there are circumstances where that would be fine.
Yeah. Okay. And the second question, which you're just about to get to now, the slide actually is addressing it. Does the caregiver agreement have to have reasonable payments to the caregiver? So you're obviously going to address that right now.
Yes, I am. And, what I have on this slide are the kinds of things that Medicaid is going to look at if it is considering whether a payment to a caregiver is not counted as a gift. Right? Because that's what Medicaid looks at is, when money is transferred, what is it being transferred for? If it's payment for goods or services, then that's fine. But if it's a gift, that may lead to a penalty. So in order to avoid that problem, we want to have a written caregiver agreement that defines how things work. So, the agreement is going to define what the caregiver is going to do and the caregiver's compensation. And it's going to be at a rate of compensation that is justifiable in the marketplace. And if we're paying a sum of money in advance, we need to look at the life expectancy tables of the beneficiary and make sure that the level of care and the compensation rate are not going to last longer than this person is expected to live under the IRS tables for life expectancy. And it's going to contain a payback provision if the care is not rendered, and the caregiver is going to have to invoice the services and keep appropriate records. And of course, it's irrevocable and non-assignable. This is all if we're paying for it in advance. So these are the kinds of things we look at if we're preparing a caregiver agreement for a client. We want to do one that is going to work with Medicaid and not cause a problem there. So let's just see. Yeah, that is our last slide. And